And welcome to our week 3 practice video. We're going to practice some work on how to do legal reasoning. We're going to take one question that we have out of chapter 23, one that you will not be doing for your assignment, so it's one that will be all new to you. But we're going to go into the negotiable instrument aspects of our work. As you know, we also are going to be dealing with secured transactions, but let's limit right now this to negotiable instruments. Because that's what our question is going to be all about. So let's first look at holder in due course. Holder in due course is typically a bank, but could also be just about anybody. It is a person who takes a negotiable instrument under certain circumstances, and if they do, then they are given certain advantages in the law that are not available to anyone else who takes any kind of instrument or contract from anybody. In fact, what it is that if we're a holder in due course, we actually take a negotiable instrument. That means we have possession of it, but then we have several other requirements, as you see here. One is we have to take it for value. We have to pay value for it. We have to give something of value for the instrument. If it's just a gift, then we don't get the niceties that we get in terms of some immunity to certain types of defenses we'll go through here in a minute. So we have to take it for value. We have to give something of value for it. And we don't really necessarily care what the value is so long as it has value. We have to take it in good faith. That means we must take the instrument with honesty and essentially good belief that we are doing the right thing, that we are honest in fact. We are taking it thinking that it is a good and honest instrument, that we're going to get paid on it. We don't have any indications that we've got something wrong going on in the transaction that may have resulted in this negotiable instrument being created. Let's just take, for an example, a check or a note that's created by someone, and a bank is going to buy that check, so to speak, or take it and give value to whoever it is that's one of their depositors. And the same for a note. When the bank takes that negotiable instrument and gives value back to the depositor, then they take the note as typically as a holder in due course. Why? Because they've given value for it. They gave money to the depositor, and they now have possession of the instrument itself. They took it in good faith. They didn't have any reason to believe that there was anything wrong with the transaction. They took it, thinking that it was going to be just an honest transaction. No problem there. And then we also have we have to take it without notice of any defect. We cannot have any notice. It means we can't have any facts or circumstances that put us on notice that it is one, overdue, has been dishonored, contains an unauthorized signature, or has been altered, or there's a claim to it by another person, or there's a defense against it that is out there in one way or another. We can't have any kind of notice when we take it. If we get the notice after we take it, that's different. But if we have no notice whatsoever of any of these defects before, then we were taking without notice of defects. And so now we've got there's lots of things that you can, defects that you could look for here that we can go through if we wanted to spend some time on that. But now, let's just assume that we know what a holder in due course is. They take for value, they take in good faith, and without notice of any defect in the instrument. Okay, that's basically what a holder in due course is. As I say, it's typically a bank in our financial system, but it can be anybody, literally. You could take a check from anybody, a third-party check, for instance, and someone can give it to you and exchange it for value. You go and deposit it and see if you can get it to be good. All right, so now let's go to our chapter 23 and look at our actual problem here. I want to look at one that you have not used before, so let's just go down to 23.6. It's one that you will not be seeing in your assignment. So we'll use that one as a good test. Now, you can go, if you wanted to, and go look at the actual case here. Let me make sure it's actually, I'm sorry, it's 23.5. You could actually go to the case because it has it right here for you. And you've seen that on your other assignments too. You can go to the case and just see how the court reasoned its way through this, and then report on how that happened, and you could get a good grade on the assignment. But I'm going to ask you not to do that in this case. I'm going to ask you to actually just try to reason your way through this, and we'll actually walk through it to help you. But the reason why I do that is because, first of all, in your week 5 you decide assignment, you're not going to have any case that will help you. You have to do your reasoning all by yourself. And most importantly, on the final exam, Everything is a fictitious scenario, and you will have no help whatsoever in helping you to legally reason your way through these scenarios. And so it's very important that you start to try and see if you can do this on your own. And this is something that you should be doing in all your assignments. You should first try to reason your way through these on your own, and then go look at the case and see how close you became to the actual reasoning of the court. And that's how you get the maximum amount of learning. All right, let's take this one. It's taking for value. This is an issue as to whether or not the company who took this note from this married couple took it for value. That's the issue here. It's Betty Ellis and her then husband, W.G. Ellis, executed and delivered a note to Standard Finance Company. It's a promissory note in the amount of $2,800, and they received in exchange a check for $2,800 that was given apparently to the husband. The check was made payable to both Mr. and Mrs. Ellis. The check was cashed after both parties actually endorsed it. Shortly thereafter, the Ellises were divorced. Mrs. Ellis claimed that she never saw or used the money, and that Standard understood that all the money went to her husband, who then later went bankrupt. When the note became due 4 years later, Betty refused to pay it, and Standard had to sue her, seeking payment as a holder in due course. She claimed that Standard was not a holder in due course in regard to her because she never received consideration for the note, and therefore Standard did not take the note for value. What happened here was, according to Betty, is that her husband told her that signing this note was simply a formality, that the note was entirely his debt and not hers. She would never be liable on the debt, and that's why she signed the note and wouldn't have signed it for any other reason. And then, sure enough, he goes into bankruptcy after divorcing her, and she's stuck with a $2,800 note she has to pay. Nice guy. But the question is now whether or not the company is a holder in due course. Well, did the company give value? That's your first question. If they're going to be a holder in due course, well, first they have to have the negotiable instrument, physically have it, which we know they do because they were suing on it. But number two is they have to have given value. In this case, they gave a check for $2,800. That check was negotiated. $2,800 got into the account of Mr. and Mrs. Ellis. Probably went to Mr. Ellis, but anyway, value was given. So value is there. Next, was it in good faith? Did this bank, or this finance company, take it just thinking this was a normal transaction where they're loaning money to someone and taking a note in exchange? Well, there's nothing to suggest anything different in the fact situation. If you actually look at the case, there was nothing indicating that the finance company knew what was going on between Mr. and Mrs. Ellis at all. And then the last requirement is whether or not the finance company knew or had any notice of any defect in the note itself. And in this case, there was nothing that gave the finance company any notice that there had been any kind of odd discussion between Mr. and Mrs. Ellis. Simply, they came in to the office. They both signed the note. They were both given the check in the names of both of them, a standard transaction of loaning money to someone on their personal promise to pay. It looks like value was given, even though Mrs. Ellis said the value was not given to her. That may actually be the case, and I'm sure that was because Mr. Ellis was kind of a real jerk. But the problem here is whether or not the bank either knew about that or somehow was a party to it or acquiesced in it or sort of knew it was going on. There was no proof that that ever happened. That means that the bank, the finance company, really had no idea whatsoever that this stuff was going on in the background. And therefore, unfortunate for Mrs. Ellis is that she had to pay on this note because we have a holder in due course. There was no defense. All the elements of holder in due course were there. She didn't have a leg to stand on. Unfortunately, she was set up by her ex-husband very badly. And that's just the way things go. That is the end of the case. There's your reasoning for this particular situation. So now we see how we take the law, we take the requirements of the law, we sort of set them out one at a time. What first one is you have to have physical possession of the negotiable instrument. You have to have taken it in exchange for some value. So the second element is value. Next, we have to have done this all in good faith and an honest transaction, and then we can't have any notice of any defects. So we went through the facts and circumstances of the case to see whether all of those elements were there. They were, and unfortunately then for Mrs. Ellis is that she had to pay on the note that she had signed, regardless of the fact that her husband told her something that wasn't true, because the bank had no notice of it. And you can see how now the holder in due course law protects finance companies, banks, and others who take these negotiable instruments from these kind of defenses where people are sort of defrauding each other, and the bank, of course, has no notice of any of this stuff going on. It appears to be nothing more than an ordinary and honest transaction. They are then protected against this kind of loss. Okay. All right, so that's it for the practice one. I just want to give you a good indication of how to do a practice problem so that you can do it on your own rather than going to the case. But if you'd like to, please do look up the Standard Finance Company Limited versus Ellis case, and you will see how that one went by very quickly. They just simply said, sorry, ma'am, you didn't have anything that indicated that the holder in due course didn't exist in this case, so I'm sorry, you have to pay the money. It sort of was the end of it. But this is at least a real straightforward way of looking at the law and reasoning our way to the final conclusion. All right, so there you go. And I hope that helps. And again, if you guys have any questions whatsoever, please feel free to give me a call and we can discuss any of these issues at any time.